All right, welcome everybody to our CALA Tuesday training. We are talking about labor law updates, and we're doing this in conjunction with our newest partnership with Employers Council. And so I'm going to have Heather with Employers Council just talk a little bit about who they are, what they are, and how they can help CALA members, and then she'll introduce our speaker today.
Hi, everybody. My name is Heather Bash, and I am with Employers Council. Thank you so much for the opportunity to chat with you and the opportunity to share some of the many changes that have happened in the past year or so with employment law here in Colorado. So Employers Council, we're kind of a unique animal. We are a member-based employers association. And so what that means is that we're actually a nonprofit organization. We're a 501c6. And so that means we're able to offer our resources at a really cost-effective rate. So what do resources mean? A membership is a really cost-effective way to get you HR and employment law consultation and resources so that you're able to pick up the phone when you've got some sort of crazy day-to-day employment issue, a sticky termination issue you're trying to handle, new laws that have come out you want to make sure you're handling correctly, anything along those lines, you can pick up the phone and talk to our certified HR professionals and our employment law attorneys that are licensed here in Colorado. In addition to consultation, we can help you with your employee handbook. You know, if you have one, we can review it for you. We can create a new one for you. Training classes is a huge part of what we offer, really well known for the quality of our training classes. Survey data, compensation and benefit survey data. So you can kind of compare where you're at with the benefits and the compensation that you're providing your staff. Helps you recruit and maintain your great employees. So that's just a very small amount of the services that Employers Council offers. Like I said, a very cost-effective way to get those resources for you and done locally. You know, we're all here, all of us here in Colorado. So I would love the opportunity to chat with each and every one of you. Just a quick 15-minute discovery call, and we can kind of figure out where you're at, what your needs are, and tailor a level of membership or services directly to you. So thank you again for the opportunity. I'm going to turn it over to my friend and colleague, Tina Harkness, who will kick off today's presentation. Thanks.
Thanks, Heather. And hello, everybody. My name is Tina Harkness, and I'm one of those employment law attorneys that Heather mentioned that works for Employers Council. Been here 25 years, going on 26, been practicing exclusively in the area of employment law for closer to 30. And it's one of those fields of law that, is like the weather in Colorado. You wait about 5 minutes and it'll change. And what I've put together for you today is a summary of the changes really just from 2023 at the federal level that affect all employers across the United States and at our Colorado level. And we know we've had a very active legislature the last couple of sessions for sure, as far as business legislation that affects employers. So I'm going to go ahead and share my screen of some slides. And Peter's going to make sure that I remember to send to you. Do we have slides or slides with notes, Peter?
Looks good.
Looks good? Okay, great. So I need my notes for a few of these, but you guys don't need to see those. So I will make sure before you ask, and maybe some of you have already typed into chat, that you get these slides at the end of the presentation. I'll send it to Peter. He's also recording this session so that you could review it, or that people who are not able to make it today or stay for the full session can get it. So we're going to do just 2023, which is a lot already. This is the legal stuff. I did say I was an attorney, so you got to have this front and center. This presentation and the materials are copyrighted by my company, and permission is needed to use them. Also, hopefully everybody's aware that I'm not your attorney. I can't give your organization any specific advice. We can talk about things generally. And if there's any follow-up, I've told Peter that I'm happy to follow up again generally, but couldn't speak to something with your specific organization. For that, you give Heather a call and you become a member of Employers Council, and then we help you one-on-one rather than on a Zoom call with 12 of your best friends. So federal, we're going to start with beginning of the year, the Federal Trade Commission put out proposed rules to get rid of non-compete agreements. So I'm not sure if these are popular in the long-term care field, but those are those agreements that generally happen at the higher levels in many industries, where certain employees, because of their important nature to the business, are asked to sign an agreement that basically says if they leave for a certain amount of time, they won't practice their profession in a different in that particular area. So it's basically a limitation on the person's ability to complete future work. So this is a restriction. And the Federal Trade Commission has been given instructions from the Biden administration to relax these restrictions so that workers can move more freely from employer to employer. So this proposed rule that was issued in January, got a lot of attention at that time, would really ban all new non-compete agreements. And it would also require employers to rescind any existing non-competes and then notify their current or former employees, because again, these affect people after their employment, and notify them that they're no longer subject to those restrictions. Colorado, you may know, already has many restrictions on non-compete agreements on its own. But really, if we get a final rule on this yet this year that is implemented, that would override, any state rule on the topic. So that is expected yet this year. But business groups have already said that they would challenge it with litigation. So it may be something that gets tied up in the court systems, as sometimes these rule changes do, as you've seen in other areas, for some time to come. We also have the National Labor Relations Board becoming very proactive, let's see, in the employment arena these days. So the National Labor Relations Board enforces the National Labor Relations Act, which is a very old law in the United States that first allowed employees for private companies. So this is not government or special districts, not publicly funded from taxpayer monies, organizations, covers private organization and allows their employees to unionize. So most of that act deals with employers that have unions or have union organizing campaigns. But one piece of that act applies to all private employers, which is the a general duties, well, not general duties clause. It's a right that all workers have in private workplaces to engage in what's called protected and concerted activity. So they can band together. It really just takes two of them to go to their employer and ask for better wages, hours, working conditions. And that would be protected and concerted activity, that workers are protected from, some job repercussions as a result. So the National Labor Relations Board enforcing that act has interpreted the act to prohibit severance agreements. So that's like the payout when you separate from an employee. So we don't always do those, but sometimes we do those for reductions in force or for trickier terminations, like Heather mentioned. It's interpreted the act to prohibit severance agreements for non-supervisor employees that require them to waive their rights to communicate with other workers, to communicate with third parties, about their wages, hours, or working conditions, which, is usually something employers want when they provide a severance payment to an employee, especially in those trickier separation situations. We'd like to have that agreement be confidential and the terms of that agreement be confidential, but that's no longer acceptable. So if you are in that situation with a non-supervisor employee where you're putting together severance agreements, please do make sure you speak to your counsel about that. Because as you could see, the general counsel for the NLRB expanded upon the decision and basically said just offering an agreement is a violation of the act, or maintaining or enforcing an agreement that's violative is a violation. You need some new posters. If you don't have it yet, here's the link to the new Fair Labor Standards Act poster. That's all employers in the United States, except for the very small, tiny ones that only operate within state borders and don't get anything from outside of the state, which is very, very small subset. It's not typically most employers functioning today. So you do need a new Fair Labor Standards Act poster. There's the link. Please grab it, put it up on, cover up the old one. There's a new Family Medical Leave Act poster as well. This is required for private employers with 50 and more employees in the US and public or government employers, regardless of their size. They just fancied it up. It's not required, but they did create a new FMLA poster. So if you want a purple poster instead of the blue one you have now, you can change that up too. There is going to be a new EEO poster. It is not out yet. So that's why I say you might want to wait. You might just want to put up your FLSA poster and cover up the old one, and then wait to buy your new all-in-one federal poster once the new EEO poster comes out. So AI is getting a lot of attention in our personal and professional lives, and government agencies are starting to weigh in on employers' use of AI at work. So the EEOC, that's the Equal Employment Opportunity Commission, which is our federal watchdog agency for civil rights violations, has issued a technical assistance document. This came out in May, on how you can use AI in employment, typically for selection of applicants. That's where it's being used most often. It could also be used for some performance evaluations, but most of what I've seen so far is in selection of candidates. And they're, of course, very concerned about algorithms being biased and effectuating bias by virtue of being used. So we've got some guidance there. We also have a joint statement that was issued at the end of April for the Department of Justice Office of Civil Rights. So they regulate public accommodations. So if your facilities, I'm sure they are open to the public to come in, family members of the people you're providing care and others. You have to pay attention to what they say about accommodation in your public setting. The Commerce or Consumer Finance Protection Bureau are the people that watch out for us citizens and different financial instruments that might be coercive. The Federal Trade Commission, of course, regulates communications across the United States, and we've already talked about the EEOC. So they issued a joint statement about that they're going to be examining AI use in all these settings and making sure that doesn't result in a biased situation. And we have states also passing anti-bias AI laws. So New York is the first, Maryland as well, and Illinois also. So it's requiring employers who are going to use AI for their hiring processes to conduct bias audits of those tools to ensure that they are not coming up with biased results. And there are also notice and reporting obligations that come with the New York law, so that people are aware that AI is being used, and we're reporting on how it's being used and the results it's getting.
Tina,
Yep.
just for my own clarification, I find that fascinating, by the way. This is primarily based in the hiring process or in however you use an AI overall?
Well, the EEOC is going to be concerned about discrimination, right? I said they are
Okay.
the civil rights watchdog, so they're
Yeah,
making sure that AI is not used to unlawfully discriminate, and that's against applicants and employees.
Gotcha.
There are many uses of AI at work,
Yeah.
that fortunately don't fall under the purview of the EEOC and
Okay.
won't be regulated by that.
Got it. Thank you.
All right, so those of you who have commercial driver's license holders who work for you, like if they're driving vehicles for you, if you offer those kinds of services with your organizations, then they are subject to Department of Transportation drug testing requirements. And the gold standard, no pun intended, for years has been urine testing for those CDL drivers. And now we have a new final rule from the Department of Transportation that approves of oral fluids drug testing. So that's the swab on the cheek and the saliva testing. And employers are really excited about this because there's some advantages, as you see, that it's not so awkward to directly observe the testing when it's a swab in someone's mouth. It also reduces the opportunities for someone to adulterate or tamper with the sample. And it detects recent drug use better than urinalysis. So it's, and doesn't, and you don't get results for as long. Let me say that too. So you're getting information that's a little bit more pinpointed. So it'll show immediately after use versus with the urinalysis after the body has metabolized that substance. Now, the disadvantages are the shorter detection window and that we don't have all the legal fights and battles fought out about oral fluids testing and what can go wrong with it yet, the way we do with urinalysis testing. So it's coming. It also tends to be less costly, which may be a factor for your organization, why you might want to consider it. But the very big but here is that you will have to wait until the Department of Health and Human Services certifies laboratories to process oral fluids tests. And they produce a list every month in what's called the Federal Register of the DHHS certified laboratories. And as of August 1st, I checked it just before this meeting, there are no government certified labs for oral fluids testing. So that's taking longer than, of course, it takes to write a regulation change, but something to be aware of coming down the pipe. We also had Supreme Court activity this year. Two decisions that were issued at the end of June, at the end of the Supreme Court term, may affect your organization. This one, Groff versus DeJoy, is a new standard for religious accommodation in the workplace. I'm going to move you guys over so I can see my notes because I need it here. Because Gerald Groff was a former postal worker. He sued the U.S. Postal Service for failing to accommodate his religious practice. He's an evangelical Christian who observed a Sunday Sabbath, and he doesn't work on that day. The United States Postal Service also doesn't deliver mail on Sundays, but it does have a contract to deliver those lovely Amazon packages that we all demand and wish to receive as soon as we order things. So USPS, they sought coworkers to voluntarily cover Groff's Sunday shifts. But when he missed shifts, they imposed their progressive discipline policy, and eventually Groff resigned his employment. The U.S. District Court for the Eastern District of Pennsylvania had held under the previous religious accommodation standard that it would have been an undue hardship to accommodate Groff with every Sunday off, because it negatively impacted his coworkers who had to fill in for him, and may have also required United States Postal Service to violate a collective bargaining agreement with their union for the hours that employees would work. Now, this case was appealed to the Third U.S. Circuit Court of Appeals, who agreed with the lower court and said that this accommodation is an undue hardship. United States Postal Service doesn't have to do it. Then it was appealed to the U.S. Supreme Court, who in a unanimous decision, in the first time in more than 4 decades, weighed in on what employers have to do to accommodate employees' religious practices at work. And they threw out that de minimis standard that we have lived with for almost 50 years. And instead, they held that employers cannot deny requests for religious accommodation unless they can show a substantially increased costs. What is substantial? How substantial is substantial? We don't know, because that's going to get fought out, and probably the cases are already coming. But we do know that it's more than an inconvenience, because that was present in this case, and that was not enough. We also know that a negative impact on coworkers, or even requiring coworkers to work overtime, is not enough to be substantial. So courts are going to have to examine, right, the impact of the accommodation on that specific employer's business based on the nature of that business, the size of that business, and guess what? Your operating costs. Because if you're going to say it's undue hardship because of dollars, you're going to have to open up your books. So this is a change. And we're going to be figuring out how substantial is substantial when it comes to religious accommodation in the next bit. Another case that got a lot of attention was the Students for Fair Admissions. And this was the case over affirmative action in college. So Harvard University and the University of North Carolina had policies that used race as a factor in admissions decisions for school, for higher education. And this was challenged under the Equal Protection Clause and the 14th Amendment of the Constitution. And in a 6-3 decision, the Supreme Court ruled that race cannot be, excuse me, let me get to my slides. It's so touchy sometimes. All right, one more. Okay, I'm not holding my mouse anymore. Race cannot be among other factors considered in higher education admission decisions. Now, you just said to yourself, Tina, I'm not running a college. Why are you talking to me about this? I'm mentioning it to you because, of course, affirmative action in employment is very related to affirmative action in college admissions. So right now, there is no direct impact on affirmative action programs in employment. Those cover, again, private employers with 50 or more employees and 50,000 or more in federal government contracts. So many of you probably receive Medicare or Medicaid program funding. That does not constitute a government contract. However, if you do contract directly or indirectly with a government agency to provide services, such as through the Veterans Administration or something like that, then you are, if you have enough employees and enough in those contracts, you are going to be covered by affirmative action, and you should be watching what develops in this area. Just a couple weeks ago, the EEOC, they've been busy with their technical assistance documents, Just like the one on AI, they issued one on visual disabilities at work. So this is the link to that document if you want to review it. It basically goes through when an employers can ask applicants or employees about vision impairments and what they should do with any voluntary disclosures that applicant or employees made. It gives examples of reasonable accommodations that people might need, how you should handle any safety concerns, and how you can prevent harassment based on someone's visual disability. I should say these technical assistant documents are guidance only. They do not have the force and effect of law, but they are certainly indicative of the EEOC's enforcement position. If you ever had a claim that you failed to accommodate someone because of their vision disability. I-9 stuff's been in the news. So for a couple of years, 3 years almost, we had the ability due to COVID precautions. So for workers that you had working off-site to protect from COVID, you could do remote inspections of their I-9 documents. So you probably have most of your employees working on site, so you couldn't do this for them. You still had to follow the regular rule where you have to personally, physically inspect the documents for I-9 purposes. But if you had anybody who was working off-site due to COVID precautions, that's done. You can no longer do remote inspections. And for those people that you remotely inspected documents due to COVID precautions, you've got to do your physical inspection of those documents by the end of this month. So if you're going back to those folks to do that. And there's instructions at this link. And oh, I forgot to take this last bullet out because this is my spoiler. Watch for future new rules. Well, guess what? We got some future new rules. So for employers that participate in E-Verify. So if your E-Verify is the program, when you hire someone, you submit their information into the government system that checks and makes sure that there's a match, right? The Social Security system is part of that gets checked, and other databases. So if you are using E-Verify, you're enrolled in that program, then you can, for new hires on or after August 1st, do virtual verification of I-9 documents in lieu of physical inspection. So you could get on a Zoom just like you are now and have the person show you the front and back of the documents, right, that they're submitting for I-9 purposes. You have to also have copies of the front and back of those documents that you will retain, but you do not have to physically be in the same room in the same place. And that is helpful for employers in our post-COVID, I don't know if we're post-COVID entirely world, but where we're hiring people all over the place because they're working remotely. And verify employers who were already enrolled in the Verify program, who did those remote inspections due to COVID precautions, could do a virtual verification instead of the physical inspection. They could do that if they were already enrolled in E-Verify at the time that they hired this person, and they opened an E-Verify case at the time that they hired that person. There is also a new I-9 form. So this I-9 form, we'll see how it works, but it's supposed to be easier. They went back to a one-page form, and they have a checkbox for employers that are using the alternate procedure. So using the option as E-Verify employers to do a virtual verification. They also have the regular 2 sections. So section 1 of the form is still. So if you're not muted, could you please mute your line? We're hearing some noise. So section 1 still contains the collection of identifying information about the new hire. and requires that person to attest whether they're a citizen, a non-citizen, a lawful permanent resident, or a non-citizen authorized to work. And then section 2 of the form contains the collects the information about the employer and the employee's identity and employment authorization documents. There are 2 supplements that you might use or you might not use. So Peter, could you mute whoever is talking? All right. There is a supplement A if you use an agent to do your I-9 process. Again, if you do it yourself, you don't need that. And there's a supplement B for re-verification and rehire, which was formerly section 3 of the form. So please familiarize yourself with the new form, get the new form. You can use it beginning August 1st, but you have to use it by Halloween. So just make sure you're accessing that. I think this might be our last slide on the federal. I wanted to put in that unions are coming back. You guys may know this because healthcare is certainly on the target list for unions, and long-term care organizations are among them. So we've had more labor action strikes, major work stoppages, or union representation provisions in fiscal year 2022 than we've had in a very long time. In addition to that, we have a shift in public opinion. So Gallup, that does a lot of polling of Americans, found that 71% of Americans approve of labor unions these days, which is up from only 48% from 2010. So this is just something to be aware of. If you see people gathering in corners of hallways and things like that, if you have a suspicion that there is union organizing going on, it's certainly something to bring to the attention of your labor counsel. Your employment attorney can help too, so that you can know what you can do to address that. Of course, we've seen all the stuff that's been happening with Starbucks and Amazon and Google and the New York Times and Trader Joe's and Apple. You know, again, unions are getting a lot of attention these days. And there's something that we may run into. All right, before we go on to Colorado stuff, any questions in the chat or otherwise about the federal stuff? Peter?
Doesn't look like anything right now.
All right. Let's talk Colorado. Of course, you know that we have the Colorado Family Medical Leave Insurance Program that's in process. We've had premium payments that began at the beginning of this year, and leave and benefits will begin in 2024. People will actually be able to apply for leave and benefits in Q4 of 2023. So family, of course, applies to most employers in Colorado. If you are a private employer who is deciding to offer a same or better private plan, then you should be looking on the family site of their approved carriers, because they're approving, right, all the substitute plans and the carriers, and talking to them about what they can offer you. So once you choose something, you'll have to, again, let the family program know. And doing that before Halloween and letting them know and getting approval before Halloween. So you can't just let them know by Halloween. You can get the premiums that you have paid into the family program since the beginning of this year back. So, and you can use that to fund your private plan. If you are small enough, if you have 9 or fewer employees, you are participating in the program, but you're only required to remit the employee's portion of the premium, not the matching employer portion of the premium. And then public sector employers, those state or local governments, school districts, special districts, they have had the option to opt out fully or partially from family, and many of them have. So here's the timeline. And again, here we are in 2023. Okay, there was one change to family from this legislative session where they passed a law that became effective in March, even though we won't get benefits from this program until 2024, that requires the weekly benefit amount for family to be calculated based on an individual's total earnings during a base period. So for unemployment, that's the first 4 of the last 5 completed calendar quarters. So they throw out the quarter we're currently in, they throw out the quarter before that, and they use the 4 before that. So that could be income from working for you if they've worked for you for a long time. It could also be income from other employers if they've worked for other employers. So that was a change. Instead of calculating benefits on earnings only from the individual's current job. So this makes it very much like the unemployment system. Another big change in Colorado that's been making its way through since 2020 is the Colorado Secure Savings Program, which is there to promote retirement savings based on the legislature's concern that many workers did not have a retirement plan available to them through their employment. So this applies to private sector employees, again, not the government or public sector, that do not have access to a qualified retirement plan. If you have such a plan for your employees, then you are just submitting, you're just registering your plan and getting exempted out of this program. But if you haven't had one, then you will need to have one. And it's a Roth IRA program. It doesn't have an employer match requirement. It's just a deduction from the employee's pay, starting at 5%, ramping up 1% per year, up to 8%. Employees can opt out, but they are automatically enrolled. So again, the hope is that they continue to participate and see the value and have some savings as a result. So this is the timeline for that. Again, I suspect that most of you have 5 or more employees, so you are either having your own qualified plan that you have registered with the state, or you're already participating in this. Colorado Healthy Families and Workplaces. So this is the paid sick leave that was passed back in 2021. And this also had the public health emergency leave component specific to our first public health emergency, which was COVID-19. So if you have any remaining public health emergency leave for employees that's on the books, that was that one-time supplement up to 80 hours of leave for full-time employees, you can take that off your books because the remaining public health emergency leave expired as of June 8th of this year. So after being extended and extended and extended, I think 7 or 8 times, it finally did end. And hopefully we won't have another public health emergency in a while that requires that additional leave. But the paid sick leave portion continues. That was not tied to COVID. And there was a bill that passed that will be effective, or was effective yesterday, right? That adds these additional reasons that employees can use their accrued paid sick leave. So it adds, again, for closures of the family member or child's school or place of care, not just due to a public health emergency, but due to weather, loss of power, water, or heat, or other unexpected occurrence. It also can be used if an employee needs to evacuate their home due to those same situations. Now, what is another expected occurrence? Again, I don't know. We're going to have to find out just because this law is new and it just took effect and they haven't issued any rules on it yet, but I expect we'll get those that give us more guidance. And then to attend a funeral or a memorial or financial or legal matters after the death of a family member. So you may need to revise your bereavement or funeral leave. You probably certainly need to revise your paid sick leave to include these additional reasons. Now, I shouldn't say they haven't issued guidance, because they have. There is, and I didn't do a slide on it, but there is an update to the Colorado Department of Labor Employment Info number 6B to define what is an evacuation. And they give the example of one employee who's needs leave after a tornado rips apart their home, basically. But at the other employee's house, just a window is broken. So the rip apart of the home, ripping the roof off, that's enough. But the window broken is not enough, according to the Colorado Department of Labor and Employment. Doesn't make the house uninhabitable. So those will be the questions we get to sort of sort our way through going forward. The big news coming out of the Colorado legislative session was the POWER Act. I just heard on Colorado Public Radio this morning a news article about this. This changes the game when it comes to what is considered unlawful harassment in Colorado. And this is the definition as it stands, the bulleted items here. What's been removed is the requirement that the conduct be either severe or pervasive. So that's a big change, because that's the degree, right, to which the conduct has to rise for it to be unlawful. And there's a fair amount of uncivil, inappropriate behavior that may occur in workplaces that we have been pretty comfortable saying doesn't rise to the level of unlawful conduct. We still want to deal with it, of course, but that precedent, all of that guidance we had relied upon is gone with this. So what we're going to be looking at is a matrix, because that's so easy. Right? Applying the totality of the circumstances to the conduct in question, looking at the frequency, the duration, whether there's a difference in power between the two parties, it's typically two parties involved, the number of individuals involved. So maybe the person's being harassed by multiple individuals versus one other person, where the harassment occurs, if there are epithets or slurs used or other humiliating and degrading conduct or language, the type or nature of the conduct, whether there's a threat involved, and whether it reflects stereotypes of certain protected classes. So a typical male, a typical female, a typical whatever else you want to put in there. If supervisory harassment is proven, employer has one out, basically, one defense, if they can show these three pieces were in place, right? We have a harassment prevention program. We have communicated our program to employees, and the employee unreasonably fails to take advantage of our program. So this aligns with a federal standard under Title VII of the Civil Rights Act, and basically protects us if an employee never tells us what's going on and then leaves and sues us for harassment. But if they do tell us, right, then we're of course on the hook for dealing with it and any of the consequences of it. Power also voids non-disclosure agreements, where sometimes when we settle a harassment claim as an employer, we will ask for confidentiality of the agreement. That's not going to work anymore. The person has to be able to communicate the details, the factual details of what happened. They may be limited in communicating the financial settlement that was reached, but they can still talk about what happened. And it does require employers to retain certain employment records for at least 5 years. And those are on the next slide. So to make sure you have the defense, you want to make sure you're investigating and addressing all alleged harassment complaints, taking that prompt, reasonable remedial action. So what's necessary to make sure this doesn't happen again? And again, communicating the details of your program. The records that you have to retain are listed on this slide. You probably are keeping a lot of this with your personnel files, but you may want to consider, again, some supplement, and they don't have a form or format for this. So it's going to be what makes sense to put this in one place for your organization. You know, the applications, they'll still be in your employee personnel files. The request for accommodation at work will be in your employee medical files, but a listing of your complaints, you know, some of the other pieces you might be creating different records for. Other to-dos, if you are under 25 employees, you have not had to prohibit discrimination in your workplace based on marital status so far, but now you do. So you need to add marital status as a protected class to your anti-discrimination policy. And if you were under 15 employees, if you had language for your disability accommodation that talked about that the disability had to create a substantial impact on the job to rise to the level of a disability, then you would need to take that out. And of course, you want to have your non-disclosure agreements reviewed. We're getting close. A couple other things that are not effective yet. So look at that yellow on this slide. You don't have to do this yet, but it's coming. So the Job Applicant Fairness Act, it prohibits asking applicants about their age, date of birth, dates of attendance at educational institutions on your initial employment applications. And there's limited exceptions to that are listed on this slide. So you need to prepare, you don't need to do it yet, to remove those questions from your initial employment application. Equal pay for equal work has been our friend in Colorado for some time. The legislature also passed some changes to that won't be effective until January 1, 2024. So again, you don't have to do this yet, but it gives the Colorado Department of Labor and Employment some additional authority to go after employers who are perceived to be violating either the equal pay portions or the job posting portions of this act. And they have a lot on their plate, but they will get after it. So we do need to make sure we're in compliance. And the other bummer part of this, real bummer part of this, is it increases the back pay awards for violations from 3 years to 6 years. So it basically doubles your exposure if you do have a compensation program that discriminates based on sex or sex plus another protected status. So prepare to do these other pieces. We're going to have to add to our job postings the date the application window is expected to close. So if you keep them open for a certain amount of time, you're going to need to add that there. And you're also going to need to provide information about the selected candidate to the people that candidate is going to work with regularly within 30 days of that candidate's hire. So what's listed on the slide is the information that you're going to need to provide to those folks. We have some updates to Info 9 on the Equal Pay for Equal Work Act. These are good things I wanted to highlight. Career progression promotions do not need to be disclosed for each individual employee. But we have to notify all of employees if we have those positions that have career progression and the requirements, plus all the other good stuff about that. So what's career progression? That's regular or automatic promotion based on time in the role or other objective metrics. So maybe they had to get a certification or something like that. So we have had to post those non-competitive situations to this point, and we don't have to do that anymore, which is very nice. Also, career development promotions need not be disclosed. So what's that? It's, again, non-competitive promotions that reflect work performed or contributions already made by one specific employee. So that will help with all the many postings that we've had to make that we didn't consider to be promotional opportunities. These are some other things that happened in the legislative session. Got one more slide, I think, after this. Military leave went up to 3 weeks of protected leave. Yep.
A couple clarifying questions here. The date of birth on applications has to be removed by next July. But then the question was, you still have to verify on documents their date of birth after their hire, which is still, that hasn't changed.
Right.
You just
So,
can't ask ahead of the a job interview or in the application process. That is going to be removed.
right. You take this off the employment application if you have a legal reason for getting date of birth at a later point, such as for a background screen, right? Because you need date of birth for that. You can still do that. Absolutely. Gotcha. And you can still, for purposes of Fair Labor Standards Act, right, ask if people are at least 18 years of age, because of course, if they're under 18, you're subject to child labor rules. And, you know, you've got certain restrictions on hours and type of work that can be performed. So yes.
And then Janelle said she came on late.
This is the slide on that.
If you have to, I'm sorry, you have 9 or less employees, you only have to pay their share of FMLA?
Of family, not federal FMLA.
Yeah, FMLA.
And you're not going to be subject to federal FMLA if you have 9 or fewer employees anyway. Well, unless you're public sector, but then you're covered, but you have no eligible employees. So for family, yes, if you have 9 or fewer employees, you are only obligated. Now you can do more. You can always do more. You're only obligated to withhold the 0.45 that is the employee's portion of that.
That's, I mean, family is 1 employee.
Yes.
Yeah, 1 or more.
Yes.
If you have
Family's
1 employee,
everybody.
you're paying the, you know, whatever
unless
the family.
You do a private plan, or unless
Yeah.
you're the state, you get the state and local government opt out.
Right.
Yeah, you're in it if you have 9 or fewer employees. You just don't have to withhold you don't have to contribute the employer portion. Is that it?
I think so.
Okay, 4 minutes. Let's see if I can do it. It's military leave went up to 3 weeks. Public employees get paid. So again, government, state and local government, special districts. Private employees can use paid or unpaid leave, but you need to provide them with that time. And employees retain their reinstatement rights for those 3 weeks. Now there's federal military leave requirements too. So don't forget those if you're dealing with that. And these are the most protective, because of course, military service is the highest form of service that someone can give to the nation. So they're very protected. We also have the obligation, not yet, to provide employees with the annual written notice of available state income tax credits. So, so this is the federal or the state, excuse me, earned income tax credit, the child tax credit. The notice can be provided electronically by email and text, must be in English or any other language that the employer typically uses to communicate with its employees. But it's not yet, it's reason I say it's not yet, it's for income tax years commencing on or after January 1, 2023. So we've not even filed our 2023 tax returns yet. We're going to be doing that by next April. So it'll be a year after that. So it's coming. And then employers can get a tax credit for helping employees buy a home. So there's the details of that are available if you want to look at that House bill. Minors, if you employ minors, it's a risky proposition anyway, but it got riskier. Minors and their parents can now sue employers for injuries outside of workers' compensation. So in Colorado, it's not, it's effective now. So if they are getting workers' compensation benefits, that's going to be offset against any remedy they receive in that suit. But you do want to be very careful if you're employing minors. And then this last Senate bill allows the Colorado Department of Labor and Employment to pay employees if they think that a wage claim is legitimate that the employee is making. They can pay it. And if the employer is refusing to pay it, as you'll see within 6 months of the Colorado Department of Labor and Employment's decision, that doesn't take you off the hook. If the CDLE pays on your behalf, employer, then the employee can't come after you, but the CDLE will come after you for that money. So wage disputes just get more and more complicated in Colorado. Pay any amounts that aren't in dispute. Keep your pay simple and easy to understand for employees. Answer their questions and resolve any disputes internally as quickly as you can. So that's it. Here's a little ad. Sorry for the ad, but we do have a conference coming up and I was asked to include that here.
Awesome.
So that's information about that. But in 1 minute, do we have additional questions?
Yeah. Well, if we got
There's a
Janelle,
hand.
what's your
Janelle.
question?
Yes, I'll make it quick. I'm sorry, I came on late. So I'm regarding 9 or less employees. The employer, are they still matching what the employee pays them for the FMLA?
For family, no.
No, so they don't have to take, so the employer is not having to pay anything at all towards the FMLA if there's 9 or less. It's just the money that the employee put in. So there's nothing withheld for the employer.
Right. It's just, you just do the employee part of the withholding.
Well,
Yeah.
are we sure we're talking about the same thing here, Janelle? Like, what do you mean by
Talking
you're
about
saying
family.
FMLA?
So, okay, what I'm saying is, so FMLA, I know that in 2024, if somebody has to take family leave, that there is money that is put aside that they can use if they have to take family leave. But
Okay.
I thought that the employer was going to have to, I thought there was some money withheld from the employer to go towards their Family Leave Act also.
Yes, there is.
There is for employers with 10 and more employees. It's required for
So
employers.
less than 10, you don't have
9 or fewer.
nothing out of the employer's pocket at all, at any time.
Correct.
Okay.
That's
you.
FMLA, but family,
That's family.
that's family.
That's family.
So which
don't-
one is the one where they're taking it out for even one employee?
You're taking out the employee's portion for even
Gotcha.
one employee. If you have 10 or more employees, you're taking out both. You're
Both
required
sides.
to take out both.
I gotcha. Both
Employees
sides.
and employees. So it's all family that we're talking about. Because if
Got
we're
it.
talking about an employer with 9 or fewer employees, you are not subject to the federal Family and Medical Leave Act or FMLA. So
But you are subject to the state. You are subject to the state.
You are subject to the
Yes.
state.
The employer is subject to the state.
Yes,
Okay. And then if they went on the state, under the state, then you would give them not only what the employer had contributed for their portion, but what they have contributed for their portion also. If you're under 9 or 10 under for state.
the benefits are administered by the state. So employers and employees at whatever level is required are contributing to the state fund. But you don't administer any of those benefits. You just administer your withholdings on the employer side.
Thank you.
So, okay. So yeah, so what you're going to have to do is to provide the leave, right? And the reinstatement and manage the employee's absence.
And they're going to calculate that base there because they have their Department of Labor has their hours and all that they worked and their pay, and then they're going to calculate their leave based on that, just like you would unemployment.
And there is actually a benefits calculator on the family website. So if you're curious what your benefit would be, what one of your employees' benefits would be, they'll have you plug in, you know, their earnings over those base period quarters, right, that are covered, and that will determine the benefit. It may not match exactly, right, what the employer and employee have contributed, because it's a sliding scale. So some lower wage earners are going to get up to 90% of their pay, which is nowhere near what you get in unemployment. You get more like 55% of your pay, right? Higher wage earners might be more towards the 70 or 55% of their pay out of the family program. Yeah. So if you're curious, you want to see how it's going to work, that's set up for you.
Okay. Thank you for that clarification.
Sure,
All
sure.
right.
Too many acronyms. It's my life.
I
but
know. It's
not
like,
every-
wait,
it's
what?
not every-
What are we talking about now? Who said what? When?
Federal,
When is
state,
that?
family, FMLA, yeah. HWFA, all this, yeah.
I would mention this too, because I don't know that it necessarily will impact us yet, but there was a bill passed last session that basically put together a small committee organized by the Department of Labor to look at healthcare pay scales and how much people in healthcare, long-term care workers were being paid. And so there's a committee that's being put together to look at that and do some evaluation and make recommendations. What that means, are we going to have to follow those or not follow those? All remains to be unseen, to be seen. But that is, that committee is currently being put together and organized by the DOL, and so anyway, something we'll learn about as we get through the next year.
Yeah. There's always something, right?
Yeah, always.
So that's where we are as of August 8th of 2023. So stay tuned, buckle up. The next legislative session for Colorado is predicted to also have a bunch of business, what they call business related legislation. So we'll see what comes from that. But
All right, other
this
questions?
brings you up to
Folks?
date. Yeah.
Anything at all? Labor related, pay? All right, nobody's
you.
piping up. I think we'll
Okay,
call
well,
it
I'll
to end. Tina, thank you so much. Appreciate it. Please appreciate Employers Council and their support. And if you do have more questions about Employers Council, reach out and we'll connect you guys. They have a ton of resources available to help you.
Yep, and I'll send the slides your way, Peter.
All right, thank you, Tina, and I'll get that out to everybody.
All right, bye, everybody.
Take care.